In this video, I'm going to talk to you about the distinction between latent and patent ambiguities in interpreting and construing wills. First, a patent ambiguity is an ambiguity or a provision in a will that has no sensible meaning. When the executor tries to apply that particular provision and carry it out according to the mandates of the testator, because of the mistake, in fact or in law, it's impossible to carry that particular provision out in the will. Patent ambiguities show themselves immediately to any careful proofreader who's editing or proofreading a will. They're obvious to see and they're obvious to spot with the eye. They're going to show themselves or manifest themselves right up front. For example, what if I wrote my will and I wanted to leave a dispositive provision and I said, I leave my house to blank? That's going to be obvious. And if I have a blank in the will document, you're going to see that I forgot to say who the house should go to. It would be a far stretch for a court to apply that provision and insert someone's name in that provision because we really truly don't know the testator's intent. Another example of a patent ambiguity would be the following. If I said, I leave my zip bar to my daughter, well, there's no English word or sensible meaning when you look at the word zip bar. It has no meaning or obvious meaning to the average person. We could perhaps use extrinsic evidence to show that if the testator referred to their car as their zip bar, then that would be the meaning. But that would be a far stretch. If you proofread the document and you saw the term zip bar, that would immediately raise a red flag. So a patent ambiguity is an ambiguity in a will, either in fact or law, that just speaks itself out and hollers out to the careful proofreader that it would be impossible to carry out that provision in the will. On the other hand, a latent ambiguity is a little bit different. With the most careful proofreading and the most careful editing of an individual's will, you would never fully see that there's a problem in terms of interpretation or application or construction of the will until you get to that point as the executor where you try to carry out the particular provision of that will. For example, I'll give you a quick example. Let's just say that the testator has property that they want to leave to their 3 nephews, and you say the following in your will. I leave my property to my nephew Alan, my nephew Bob, and my nephew Carl to be split equally and divided equally among my nephews. Well, that sounds good. If you have a nephew named Alan, Bob, and Carl, no problem. It'll be easy to carry out that provision. And when you look at it in an editorial or a proofreading sense, it doesn't look like it's any sort of mistake or ambiguity when you look at the provision on its face. However, let's just say that the testator had 2 nephews named Carl. One nephew named Carl that they were really, really close to, and another nephew named Carl who they despised and they hated, and it was their clear intent to disinherit that particular Carl. That would be a problem in interpretation. The executor would have to pick which Carl that they're going to choose from. So this is real problematic when you have 2 individuals by the same name and they're named in a provision in a will. Let's just say, or give you another example. Another example would be the following situation. What if I said in my will that I leave my car to my son at the time of my death? Well, I use the word car. What if at the time of my death, I own 3 cars at the time of my death? 2 were clunkers and 1 was a really, really nice brand new car. Which one of the 3 cars would my son get? I only use car in the singular sense and I didn't say cars in the plural sense. So that would be a problem of interpretation and actual application that the executor of the will would have to wrestle with. So under the common law, we looked at ambiguities very harshly. Under the common law, we were faced with a strict compliance doctrine, and a doctrine that really forced us to not allow any reformation or extrinsic evidence into the process to interpret a will. If it wasn't clear on the four corners of the document, on the will itself, on the face of the will itself, we could not bring in any oral testimony or written testimony or proof to show what the testator really truly intended. So, faced with this rule, which was a very harsh rule, these interpretive problems became really daunting for any executor to carry out. Nowadays, with reform efforts, with efforts like reformation and the allowance of the use of extrinsic evidence to show with clear and convincing evidence what the testator truly intended, we now allow oral or written testimony into the courtroom and into the probate process to show what it was the testator really truly intended. If there's an ambiguity in fact or law on the face of the will, it could be a patent ambiguity or it could be a latent ambiguity. I hope you found this video helpful and these examples helpful to kind of sort through and filter through the issue of patent and latent ambiguities. Thank you for tuning in.